Welcome to Do It for the Case Law for Friday, July 10th, 2026. Visit doitforthecaselaw.com to listen to more in-depth per-case reporting. Today's docket features 68 federal appellate decisions across 9 circuits. We have coverage on criminal justice matters, including drug trafficking and firearms cases with James Taylor. Aisha Johnson brings civil rights updates covering employment discrimination and Section 1983 claims. Michael Reeves reports on constitutional law and habeas corpus petitions involving Section 2255 relief. Maria Santos handles business, labor, and civil disputes ranging from bankruptcy to insurance litigation. Patel covers immigration appeals and administrative agency reviews, including Social Security matters. If you want more federal appellate analysis delivered daily, please subscribe to the show. Do It for the Case Law is a news reporting service. We summarize and discuss federal appellate opinions. Nothing in this broadcast constitutes legal advice. Let's turn to James covering criminal justice.
Thanks, David. 26 cases across 5 circuits today. The disposition roll-up shows 8 affirmances, 10 dismissals, 3 denials, 1 vacatur with a remand, and 4 other dispositions including procedural rulings. Starting in the 11th Circuit, the court vacated Rolex Brian Bruno's carjacking conviction and remanded for a new trial after finding plain error in an Allen charge that omitted critical language about jurors not having to surrender their honest beliefs. Moving to the 4th Circuit, Charles Raymond Wable's 180-month sentence for firearm possession and witness tampering was affirmed, despite arguments over his prior marijuana conviction. Mark Leslie Lively's methamphetamine conspiracy convictions were upheld after a review of suppression and Brady claims. DMARC advisor BV lost its appeal against a preliminary injunction for Lanham Act violations involving targeted U.S. sales, and Dontrell Marquis DeMarcus Gilmore's fentanyl distribution sentence was affirmed, with the court rejecting arguments about drug weight calculations. Over in the 5th Circuit, 4 Anders appeals were dismissed without reaching the merits. Carlos Alex Moreno Olivero, Eldridge Jackery Fountain, John Earl Edwards, and Mario Ramirez Martinez all saw their appointed attorneys excused for lack of non-frivolous issues. Darren Tremaine Jackson's methamphetamine convictions were affirmed based on sufficient circumstantial evidence. Terrence Taylor Sr.'s 210-month sentence was upheld after he waived challenges to within-guideline sentences. Juan A. Boinca trial. Payne faced an affirmed sentence where a Mississippi expungement did not remove his prior marijuana conviction from his federal criminal history score, and a sealed appellant's 140-month drug conspiracy sentence was affirmed despite claims about the district court's substantial assistance motion. Tristan Barber received an affirmed 180-month sentence for firearm offenses with cross-reference enhancements for attempted murder upheld, while 2 other appeals regarding transcript corrections were dismissed for lack of jurisdiction, but affirmances of underlying convictions remained in place. Billy Cooper's request for sentence reduction was denied as a life without parole carjacking sentence stems from statutory command rather than guidelines ranges, and Rishan Lamont Scott's supervised release revocation was affirmed after he failed to properly preserve plain error arguments. In the 6th Circuit, Gary Cunningham's methamphetamine distribution convictions were upheld based on sufficient circumstantial evidence. William Garnett Cornwell's 72-month federal sentence was affirmed without a ruling on concurrency with state time. Ryan Baugh's lawsuit against the Central Intelligence Agency was dismissed for lacking an adequate remedy in court under the Administrative Procedure Act, and Michael Thomas's 120-month stolen firearm sentence was affirmed after he invited any error by declining to request new counsel. 8th Circuit affirmed Christopher House's 100-month fentanyl sentence with an upward variance justified by policy disagreement, and denied compassionate release motions for Isaac Lee Loggins and Barton Crandall, citing non-retroactive sentencing law changes as not extraordinary under Rutherford and for impunity. Finally, in the 9th Circuit, Ivan Kitu Sanford's conspiracy to rob conviction was affirmed after the court found the attempt failed due to outside intervention rather than voluntary abandonment. Mario Jones's supervised release revocation was upheld based on multiple violations, including drug test failures and threats against a probation officer. Back to you, David.
Thanks, James. Now for civil rights coverage with Aisha.
Thanks, David. 5 cases on my beat today. 4 were affirmed or dismissed. 1 was split with a remand. The 4th Circuit split its decision in the age discrimination case against Dr. Lee, affirming summary judgment on most claims but vacating and remanding his specific retaliation claim regarding the accelerated removal timeline from his neurosurgery chair position to determine if age was the but-for cause or if retaliation drove the action. In the 11th Circuit, a Title VII hostile work environment suit against Atlas Air and its partner was dismissed for lack of personal jurisdiction over one defendant and failure to state a claim against the other due to insufficient allegations of discriminatory intent. Also in the 11th Circuit, an employment dispute involving retaliation under the Civil Rights Act of 1964 and the Americans with Disabilities Act ended in affirmation for the Florida Department of Corrections because the plaintiff failed to provide competent evidence that his EEOC filing or accommodation request caused his termination. Finally, the Ninth Circuit affirmed the dismissal of a Section 1983 suit against Washington state natural resources officials, ruling that the agency enjoys sovereign immunity and is not a person subject to suit under the statute. Back to you, David.
Thanks, Aisha. Now for constitutional and habeas developments with Michael.
Thanks, David. 7 cases in this block, 5 affirmed, 1 dismissed, and 1 denied. In the 11th Circuit, the court affirmed liability against Hillsborough County for wrongful death while rejecting a Fourth Amendment claim against Deputy Mark Clark, holding that the sheriff's office lost sovereign immunity by failing to notify the decedent's parents and release him to a responsible adult as an operational decision rather than a protected planning function. The court also affirmed the denial of a renewed motion for judgment as a matter of law on the Fourth Amendment claim, finding probable cause existed given evidence that the decedent ran through chaotic crowds while engaging in disorderly conduct. Moving to the 5th Circuit, the court dismissed Peter Victor Ayika's habeas petition under Section 2255 of Title 28, ruling he could not bypass successive motion restrictions using a Section 2241 claim based on Ruan du United States because Jones v. Hendricks abrogated the saving clause argument. The court also affirmed the denial of Jason Michael Schubert's Section 2255 motion, finding no prejudice from an erroneous sentencing guideline enhancement for sophisticated laundering since the underlying statute applied only to a different offense. In the 8th Circuit, Garnell Carter's appeal was partially affirmed and partially dismissed due to a valid plea waiver covering offense-level calculations and criminal history, though his challenge to the offense level conflicted with sentencing guidelines text regarding felon in possession enhancements. The court also dismissed Lakemia DeAndre Castor's appeal enforcing his plea waiver regarding the denial of a motion to withdraw his guilty plea, finding he knowingly waived rights concerning methamphetamine charges involving 500 grams or more under Section 846 and 841 of Title 21. Finally, David Hirsch's petition was denied because consecutive sentences totaling 120 months for drug offenses and felon in possession violations under Section 924 of Title 18 made him ineligible for First Step Act time credits when aggregated. Back to you, David.
Thanks, Michael. Now Maria has the business and civil law roundup.
Thanks, David. 14 cases across 4 circuits. The 4th Circuit handled 6, the 6th Circuit dismissed 1, the 7th Circuit remanded 1, and the 9th Circuit decided 6. In the 4th Circuit, we see 2 outcomes that changed the lower court's result. DeMarcian versus Presley McEuley Millen was reversed on a civil contempt finding because there was no clear evidence of actual harm to the opposing party, and Elena Garcia Chilel versus Acting Attorney General Blanche was granted and remanded due to a defective notice to appear and an abuse of discretion in denying a continuance for a U visa application. 3 other 4th Circuit cases were affirmed. Paul Schultz versus Trustee Gold McCarthy in a bankruptcy dispute involving conversion from Chapter 11 to Chapter 7, Pocahontas Cole versus Director of Workers' Compensation regarding black lung benefits under Section 3901 through Section 945, and Shirley Boatwright versus Pamela Valdez for failure to exhaust administrative remedies in a Federal Tort Claims Act case. The 6th Circuit dismissed the Miners versus state official Carrie Kent, ruling that their petition clause claim failed and sovereign immunity barred their state law claims. In the 7th Circuit, William Clements versus Gunnar Optic was remanded because the district court incorrectly applied a HIPAA exclusion to an Illinois Biometric Information Privacy Act complaint regarding virtual try-on services.
The 9th Circuit had 4 immigration cases granted and remanded. Nava Perez versus Nissan North America was vacated and remanded on removal jurisdiction where the amount in controversy was plausibly alleged. Piaczynski versus the United States was remanded for inadequate biometrics notice to non-English speakers. Epina versus Blanche was granted because the immigration judge denied a reasonable time to secure counsel during the pandemic. And Ruiz Acosta versus Blanche was also remanded for similar biometrics notice. Failures: 2 Ninth Circuit cases were affirmed. Law offices of Robert Joby versus Zurich American Insurance regarding the duty to defend under an employment practices policy before self-insured retention exhaustion, and Intellectual Pixels versus Sony Interactive Entertainment, where the Patent Trial and Appeal Board's obviousness finding on U.S. Patent number 10681-109 was upheld. Finally, Piaczynski versus the United States in the Federal Circuit was affirmed for lack of subject matter jurisdiction under the Tucker Act. Back to you, David.
Thanks, Maria. Now for immigration and government updates. Let's turn to Raj.
Thanks, David. 16 cases from today's docket in immigration and government law. The disposition roll-up includes 2 affirmances, 5 dismissals, 3 denials, 1 split outcome, and 5 vacators with remands or rehearings. Leading the day, the 5th Circuit vacated its own panel opinion in consolidated immigration cases involving Ignacio Cisnava Rodriguez, Alejandro Villegas Angel, and Miguel Angel Gomez Alvarado, ordering a full court en banc rehearing with oral argument to be scheduled later. The Ninth Circuit also vacated and remanded a district court order in Ameshuia versus Nissan North America Inc., holding that the lower court erred by excluding civil penalties and attorney's fees from the amount in controversy calculation for federal diversity jurisdiction. In the 10th Circuit, Energy West Mining Company's petition regarding black lung benefits was affirmed after the court found the ALJ acted within authority to reopen the evidentiary record sua sponte. The same circuit affirmed a dismissal in Parker versus Bisignano, because the petitioner failed to exhaust administrative remedies by skipping the Social Security Administration Appeals Council. Over in the 4th Circuit, the court denied a petition for mandamus from Clarence Hicks Jr., ruling that his request to lift an indefinite leave to reply did not meet the high burden required for such extraordinary relief. In the 8th Circuit, the court denied Jose Antonio Molina Malaga's immigration appeal because he failed to meaningfully challenge the agency's finding that he lacked good moral character. The 9th Circuit also denied asylum petitions from Aragon Lama de Morales and Lina Gomez Parra, upholding the Board of Immigration Appeals' decisions based on substantial evidence regarding the nexus of harm and procedural waivers. Additionally, the 9th Circuit affirmed a denial of supplemental security income benefits in Taylor v. Bisignano, finding substantial evidence supported the ALJ's assessment of the claimant's residual functional capacity. Moving to the Federal Circuit, the court dismissed appeals from Charters v. Collins and Limon v. Collins for failure to prosecute and lack of jurisdiction respectively, while Busby v. DHS was dismissed by agreement with each side bearing its own costs. The court affirmed the Merit Systems Protection Board's decision in Hart v. MSPB regarding an accepted service appointment, ruling the appellant did not qualify as an employee under federal statute. Finally, the Federal Circuit remanded IQE plc versus Newport Fab LLC after the parties filed a joint stipulation of dismissal. Back to you, David.
Okay, so that wraps up Do It for the Case Law for Friday, July 10th, 2026. Thank you to our reporters, James Taylor with 26 cases on criminal justice and violent crimes, Aisha Johnson with 5 cases covering civil rights, Michael Reeves with 7 cases on constitutional law, and habeas petitions Maria Santos with 14 cases on business, labor, and civil matters, and Raj Patel with 16 cases on immigration and government issues. Today's docket saw 1 reversal or remand, 30 affirmances, 15 other dispositions, and 22 dismissals. The single reversal or remand stands as the most significant outcome of the day's proceedings. Several appeals were dismissed on procedural grounds or for lack of jurisdiction. Visit doitforthecaselaw.com to listen to more in-depth per-case reporting. Do It for the Case Law is a news reporting service. We summarize and discuss published federal appellate opinions. Nothing in this broadcast constitutes legal advice. We are not lawyers. If you need legal counsel, consult a licensed attorney in your jurisdiction. Please subscribe to the show and follow us on social media for daily updates.